Hello, hello, it's Patty Joe. Sorry for the break. I worked 3 nights in a row. That frigging kills me. Okay, I am sorry. I literally slept an hour and a half for every hour that I worked over those last 3 days. So I fell off on comments. I fell off on everything. There's a bunch of comments I might start looking through and taking a quick look at. I'm also still feeling kind of under the weather. So hot drink, forgive me if I have to take a break for a cold one. We are at the start of day 8 of this. Hello, I do this for my opinion. So the lady who said I'm very opinionated, thank you for your opinion. Keep it up. Maybe you have some opposite opinions and we can talk about them. Or I don't see it one way and I should. I'm fine with that. All right. Moving along with Dirty Darrell here and his... Is he reading the Bible? Is that the Bible already? Are we already starting with his shenanigans? Oh my gosh. Every once in a while, because I watch so many of these with you guys, I fall asleep sometimes to music or to raindrops or whatever. It'll click over and I'll wake up in the middle of the night and it'll be, some weird hearing of Darrell's. And I'll be like, oh, nightmare. Okay, let's get through this. Let's see what he's got going on here. I almost kind of like watching before they actually go on the record because I think his act starts here. What do you guys think? I think he's already acting. Is this preparing? Is he preparing? Are we actually witnessing all of his preparation? I know the sound is working because they did one of my testing things. So they are not on. There we go. It's gonna be pretty soon.
Thank you, everyone. Please be seated. Good morning. Oh, it's chilly in here. It's probably they adjusted it. We'll need to call them and tell them to bump it up a little. Now that the weather changed. No, it's. I would find out what the temperature set at. It's cold. It's definitely like an ice box in here. All right, good morning, everyone. Court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Yes, good morning, Judge Schuapper, Leslie Basie, and Zach Woodshaw appearing for the State of Wisconsin.
Good morning, sir. Your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Then let's all go home.
All right, the record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothes. He is wearing a suit, I believe a tie, can't quite see around the monitor, and a mask.
Oh no. He's not getting full.
Your objections noted for the record. The appearance, as I've just indicated, stands. I do want to advise the parties today that one of the jurors called in this morning and was not feeling well, and I did excuse that juror. So that will mean at the appropriate time, when the court selects the alternates by random lot, I will only be selecting 3. I believe that was juror number 35. All right. Anything preliminary before the jury's brought out for the continuation of testimony from the state?
Is the audio on, Your Honor?
No.
Okay, thank you.
All right. Sorry about that.
The only thing, housekeeping to clean up, Your Honor, is Exhibit 15, which was the victim map that we had first introduced through Detective Casey, and you admitted it subject to proof of all of the events that are depicted on the map. We believe we have now reached that point where it can be admitted in full. I do have a poster-sized copy of that exhibit that's also marked as Exhibit 15. So we have Exhibit 1.
Okay, I think I finally know what
is
she's
the
talking
map
about.
of the downtown.
I've watched the scene a bunch of times. She's talking about how that map had all those names of all the injured and unalived parties in it, and it was moved into evidence, but it wasn't like moved into evidence fully because they had to lay foundation for each and every part of that. Now that they have gone through all of the crimes, thank heavens, because that was so long, that was so many, it was so hard, that now that piece has all the foundation has been laid. Now I think I understand that. Correct me if I'm wrong.
Area. Exhibit 15 is the
Yes,
what we have
sound like Rob.
termed the victim map, or the parade victim map. That's a hard copy of that as well, and then I have a third one that I'll be introducing later today or tomorrow. But we just wanted to clear up on 15 that all of the information on that map has now been testified to, Your Honor.
I did admit it subject to the full foundation. Any position on that, sir?
Oh my God.
To it being admitted.
Yes, fully received. I had received it subject to foundation, and the state's set forth its position. Do you have any position on that?
Yeah, I object to it. I don't see the relevancy.
Of course.
All right, your objection is noted, and Exhibit 15 is received. I believe I told the jury it was received subject to
is noted
that
and fully ignored.
foundation, but I will advise them that it's been received by the court when they come.
I know a lot of you like don't like the way she handles some of this stuff, and there are pieces that I like fully behind you. There are pieces that I'm like, I get what she's doing, but you know, and I don't know how to do the job, so I'm not going to make a judgment. And there are pieces I'm fully behind her. This is one, she does this fairly consistently where, you know, he brings up these ridiculous comments, which are not arguments in any kind of legal form that even a layperson can see. And she just washes right over them. Okay, well, thank you for your comment, but, you know, here we go anyway.
Come out today.
All right, and then one other housekeeping matter. Last week, I believe it may have even been on Thursday, we had a discussion with Mr. Brooks outside the presence of the jury in which several broad topics were discussed. One of them was Mr. Brooks had indicated he did not have a pretrial offer from the state. We would ask the record to reflect that afternoon we did provide him again with a written copy of our pretrial offer, and that was placed with his materials on the table. I just wanted that in the record, please.
I object to that. I don't. if it was with my paperwork, I haven't seen it.
It was specifically one of the papers, sir, that you left in the bullpen area that on the next morning, on Friday morning, I made a record of providing back to you. So it was provided to you twice.
Well, I haven't seen it.
Because I didn't
Want to put
accept
the
value,
offer
which
on
you
the record,
reviewed.
Attorney Opera?
Give me 1 second.
Which, by the way, is I don't know what that means, but I'm thinking it's a soft-set thing, except for value, return for... Meaning he's trying to make it some kind of like financial exchange, I'm guessing. I'm so
Second,
sorry,
Your
I'm
Honor.
going to stay out of this.
So what's the significance of it being on the record? If
So that you are fully aware of it, sir. It was provided to you, but you're indicating you haven't read it, so I want them to make a record of it. The significance would be, I suppose, if at any point you wanted to change your plea, you could do that based upon the pretrial offer.
well, in any event, I accept for value and return for value that document whenever
Which I have never seen.
whenever I see it.
Whenever I see,
Attorney Opera, go ahead.
he's so predictable now.
Sorry,
It didn't even
just take me a
take
second.
half the trial to be able to
Retrieve it here,
figure
Your
this.
Honor.
Sorry.
Your Honor, this would be a perfect time to address the subject matter jurisdiction that has yet to be proven on the record and must be
Mr.
proven
Brooks,
by the prosecution.
we are not going to address that. I issued a written decision last week. If you disagree with that, then you can take that up to a higher court. But I issued a written decision. I'm not
Higher
addressing
court.
that any further.
It has yet to be proven on record.
God.
Mr. Brooks, my written decision is the decision of this court.
Has it
Attorney
been
Opera,
proven?
go ahead.
Has it been proven on record that you have subject matter jurisdiction? Because it has yet to be proven.
Mr. Brooks, your position is simply not correct as a matter of law. I explained that.
Then prove it
and
lawfully
I issued
by
the
law.
decision.
Lawfully
You
by
might be
law?
confusing subject matter jurisdiction
by
with
treaty?
venue, which is why I commented on that last week.
Absolutely
And there
not.
has been evidence received regarding venue. So I'm going to turn back to Attorney Opera.
has nothing
She's
to
going to
do
make
with
a
venue,
record of
Your
the
Honor.
pretrial offer. I'd ask that you not interrupt. Thank
Just
you.
said it has nothing to do
Your
with
Honor, the
venue.
offer that was dated July 5 of 2022 reads as follows. Plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts. The defense is free to argue. This pretrial offer was conveyed to his prior counsel on or about the July 5th date. And there, in fact, had been a earlier offer as well that had been relayed prior to the preliminary hearing or the filing of the information back in January of 2022 that had also been conveyed to his defense counsel at the time.
All right, thank you.
So why haven't I been informed of that?
All right, Mr. Brooks, that is not a topic we are going to take up any further. I just wanted the record to reflect that offer was conveyed to you.
It wasn't conveyed to me, Your Honor. This is the first time I'm hearing of it. So if it was conveyed to my former
It's
counsel,
not something I'm going to. It's not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do. So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
and in all respect, Your Honor, I don't think it's fair that you should assume what I want to do or not, or what I don't want to do.
Put it in writing.
I just need to make a record that that paperwork was provided, sir. We'll continue with the testimony today. I'm not going to take up subject matter jurisdiction. I've issued a written decision. Is there any other preliminary topic from either party?
Is
Mr.
that
Brooks?
is that decision verified proof that subject matter jurisdiction
Yes.
exists? Because it has yet to be proven on the record.
All right, your objection is noted. Please bring the jury up.
Your Honor, is that the answer?
Yes.
Mr. Brooks, I issued a written decision. That's your answer.
And what's
That's your
that?
answer.
And what does the written decision entail?
So that was provided to you last week. I'm not going to
I
go
accept
through
for
it again.
value and return for value the document that I have not seen. What does it entail, Your Honor?
Sir, you were provided with a written copy. I'm not going to read it into the record at this point. It is part of the record. It's a final order
If
for
it's part of the
purposes
record,
appeal.
why can't it be read into the record right now?
It doesn't need to be read into the record, sir.
Is it
It's
verified
part of the
proof
record.
of? Is it verified proof of subject matter?
Mr. Brooks, I'm not answering that because it's not something that needs to be verified.
It
have a
has
mistaken
to be
belief. Right.
verified
Is
by
the
the
jury
prosecution.
No, that's in a civil matter. That's in a federal.
Or is that a tacit
That
agreement
doesn't-
that you don't have to answer that question or verify proof of subject matter
Sir,
jurisdiction?
I have no such
No, 'cause there's
agreement
no
with
such thing
you,
as tacit.
tacit or otherwise. So
Maybe tacit agreement.
that's not
which
how
is
this
some kind of
operates.
weird thing
Again,
in law.
just
So
because
would
you
it be
believe
proven?
the law requires, that doesn't make it true.
Thank you.
All right, the
Show
jury's
me
coming
lawfully
out. All
law.
rise for the jury, please.
Show me by lawfully law that you have subject matter
These are
jurisdiction
words
because it
I'm
hasn't
making
been
up.
proven on the record. It has yet to be
Here
proven
in
for the
front of the
record. Let the
jury.
record reflect that.
Here
The
he
record will
goes.
not reflect that, and the jury will
His
disregard the comments
Toddler
currently being
behavior,
made.
thinking
record
he's
should
doing
reflect
that.
something
Mr. Brooks.
because he's arguing these things
You have to put it on the record.
in front of the jury, and he thinks he's
Otherwise, that'd be tampering with the
doing.
record.
Guaranteed, all he's doing is pissing them off.
So at
Ugh.
8:40,
All right. Good morning, everyone. Please be seated.
tacit agreement at 8:40.
All right. Please disregard the.
You know what this reminds me of? This reminds me of my advice to new parents who have the new toddler thing going on in like the big stores like the Targets and the Walmarts and stuff like that. And they want their toy or their candy or whatever it is. And they start throwing a fit. And I'm like, no, don't I stop this. Try to stop this. Just pull back into the crowd. Just melt yourself back into the crowd. And say, isn't that terrible? Until they're finished. Unfortunately, this is an adult. And this behavior is being done in front of a jury who's trying to do a job. All these people are trying to do a job. He's trying to make a mockery of it, which just compounds all of the crimes that he has committed even further.
The most recent
we cannot
comment
build
by
back
Mr. Brooks. It's not evidence in this proceeding.
Ugh.
All right, the statement call its next witness.
Thank you, Judge. The state calls Sean Backler.
Subject matter jurisdiction
I like her
Jury will
outfit.
disregard that last statement by Mr. Brooks.
has to be on the record.
I was just thinking about this, and let me voice my opinion again. Sue Opper's outfit is just awesome. I love the understated, really nicely, you know, she's got the sweater, she's comfortable, but she's professional. She is put together, but she's casual at the same time. She doesn't overdo anything. I bet my first thought when I saw this outfit at first when she was showing that exhibit earlier was, wow, I bet when she dresses this up to go out for a drink after work, she probably, or hors d'oeuvres or whatever she does, I don't know if she's a drinker or whatever, but when she goes out with her colleagues after work to unwind or goes out with her family to unwind, I bet when she like spruces it up for that out part of her day, she just blooms. I bet she just looks totally different, like ugh. But this is just so Sue Opper, I love this outfit for you. I love the whole look for her on this one. Absolutely appropriate enough.
Good morning, sir. Please make your way to the witness stand, which is all the way up by me. To my right. When you get there, please remain
I was over
standing,
this
raise your
one.
right hand, and my clerk, Teresa, who's on my left, will swear you in. There is one riser, so just be mindful of that.
Where's I've been in bed for a day now.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you,
Oh.
sir. Please be seated.
I know this guy's gonna be fun.
The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Sean Backler, S-E-A-N, last name B-A-C-K-L-E-R.
All right, go ahead. Your witness.
Thank you. Good morning, Mr. Backler.
Hi.
Sorry.
Sir, on November 21 of 2021, where did you live?
Objection, relevancy.
Overruled. You may answer, sir.
409 Central Avenue, Waukesha, Wisconsin.
Okay, if you could just keep your voice up a little bit, please.
Oh, I'm sorry.
Yeah, that's maybe better if you scoot a little closer to the microphone. Okay, 409 Central Avenue, and that's in the city of Waukesha?
Correct.
Okay. Around the time of 4:49 p.m. on that afternoon of November 21, where were you?
Overruled. You may answer, sir.
I was outside working around the yard. Had my garage open.
Okay. Were you aware that the annual Christmas parade was going on that afternoon?
I was aware of it, yes.
Did you attend the parade, sir?
No, I
Objection,
did not.
relevancy.
Okay.
Overruled.
Around 4:49 p.m., what happened, sir?
Objection, leading the witness.
Overruled.
I heard some noise around on the east side of my garage, and I went to see what was going on, and I found the defendant on the side of my garage. I asked him, what in the effing hell is he doing?
Okay, so let's slow down a little bit. You heard a noise and you went to explore it, correct?
Correct.
And you saw a person there,
Yes, I did.
and you questioned that person for being there. Is that right?
Objection, leading the witness.
Foundational, Your Honor.
This is overruled. You can answer. I'm not sure if you did or not.
I asked him what he was doing there.
Okay, and maybe you were cursing at him. Is that what you're suggesting?
Objection, leading the witness.
Overruled.
I think I dropped an F-bomb on him.
Why?
He was trespassing.
Okay.
So he dropped an F-bomb on him because it gives you an illusion of some sort of stability and power in your own environment. I used to, argue this all the time at the fire department, which was, you have to have control over your medic unit. You have to have this, and you guys don't have control over it. I'm like, it's an illusion of control. Okay, you are in a box with a stranger who's likely, a lot of these people in my jurisdiction were homeless. They have backpacks or bags. All of the homeless have some sort of sharp object like a box cutter or something so that they could protect themselves. So there was not one person that I assumed coming into the back of that medic without a weapon. So to curse gives you like an illusion of your power in that situation. And I do call it an illusion because that's all it is. But sometimes that's all you need. It's kind of like with a bear. You make yourself look bigger and the bear gets scared and runs away. It's an illusion of power. It's not reality.
The person that
There
you
was an objection, but it's overruled.
Because he doesn't know what
the person that you saw, can you give us a description of that person, please?
When I called it in on the non-emergency line at the Waukesha Police Department, I described him at about
He's not gonna be able to take this guy
5'8",
apart at all.
probably weighed about 150 pounds. He was either black, mixed, or Latino male, wearing a red shirt, jeans, long hair, beard, and I think he was missing his shoes.
Okay. You said red top?
Red shirt.
Objection, leading the witness.
Red shirt. What kind of shirt?
Overruled, and his answer may stand.
He was wearing a red chino.
If there is an objection, please just wait until I rule on it first by saying either overruled or sustained. And I'll let you know if you can
automatic
answer the
Darrell.
question.
Okay, I'm sorry.
That's okay. Go ahead.
Totally.
I believe it was a red T-shirt.
Okay. To your way of thinking, was he dressed appropriately for the weather?
Objection, leading the witness.
Overruled. You may answer.
Relevancy, objection.
Overruled.
He's going to multiple object. He's going to object in multiple ways to each and everything said because he doesn't want anything this guy says to come in. None of this guy supports his made up reality of what happened. I don't think Darrell could possibly even say what happened because he is so narcissistic. He has so reinvented reality about every part of this that he just can't let any other part of actual reality come into his bubble of deceit. The bubble of deceit. That might be it.
Immediately, it just seemed off because he was wearing a t-shirt. If I remember correctly, he was not wearing shoes. It was very cold out. He was sweating. His eyes were huge, and he was just acting. When he came out from the garage, he was asking if I could call him an Uber.
Okay. So you spoke with him a little bit?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Very shortly.
I have to ask him
She
a
needs to
question.
rephrase her question.
Oh, I'm sorry.
That's okay.
Did you speak with him?
A little bit.
Okay. What do you remember him saying?
He kept asking if I could call him an Uber, and then he said I need to get home.
Yeah.
Did you agree to call an Uber for him?
No, I said I needed to leave my yard.
Okay. And did he comply with that?
Yeah, he did. He just kept asking if I could call him an Uber, or if he could use my phone. I said, you just need to leave. And
The person that you're describing for us, sir, do you see him present in the courtroom here?
he's sitting over there with the mask on. And
He's the guy who's going to
Have I asked the defendant be instructed to remove the mask?
Mr. Brooks, please remove your mask.
He will lift his head.
And if he would look at the witness, please, Your Honor, with his head down, it's not to assist.
All right, Mr. Brooks, please look up and look at the witness. Look at the witness, please. Thank you.
Is that the man that you're describing that was in your backyard that you spoke to?
Objection,
Yes.
leading.
Overruled.
I want to show you a photograph. It's going to come up on that screen there next to you, okay? Just let me know when it's up. The system takes a minute to warm up, especially first thing in the morning. Is it up?
Yep, it is.
Okay. Do you see this photograph, sir?
Yes.
Objection.
And
Overruled.
What?
Yes.
I'd like you, is there a person shown in the photograph?
It's the
Objection,
defendant.
leading.
Overruled. It's not leading. You may answer.
It's the defendant.
Is this consistent with his appearance when he presented himself to you on your driveway that evening or backyard garage area?
Objection, leading.
Overruled. You may answer.
It is consistent.
Okay. Move to admit and permission to publish 171, Your Honor.
Objection, relevancy.
Your objection is overruled. Exhibit 171 is received. Permission to publish is granted. The jurors will also let us know when the image is projected in the jury box.
Oh,
And sir, it's a little hard to tell in the photograph, but was the t-shirt he was wearing a short sleeve or long sleeve, if you remember?
Objection, relevancy.
Overruled.
It was a short sleeve shirt.
Okay. Ultimately, did he leave your property?
Objection, accident, answer.
Overruled. You may answer.
When he was leaving, he was kind of taking his time, and then I told him he needs to leave again, and started walking towards him as he was leaving, and he lifted his shirt up and said he was unarmed.
Okay. Had you asked him about any weapons?
I had not.
Objection,
you know what? Had I not done the job I did in the jurisdiction I did, that whole lifting the shirt up thing unsolicited would have been completely bizarre to me. So for everybody who lives a normal life, in normal society, let me just tell you that if you're constantly seen as a threat and there's a pocket of people who are seen as threats, and it's not really fair for them to be seen as threats just by the way they look. It's absolutely unfounded. There's no reason for us to do this. But Darrell is not in that pocket of people. Darrell's not in that group. He's in a group of people who has seen as threats because they are threats, because they have done things to people, because they're normally lifting up and showing their waistbands to prove they're not packing something. I mean, it's, ugh. And, you know, that, I don't want to go into whether I agree with people carrying or concealed, whether they can have weapons or not. Just beyond that, you don't. If you're carrying, doesn't mean you're a threat. If you're a threat, doesn't mean you're carrying. But this is a normal event for him, is to prove to everybody that he's not a threat, so that he is a victim, and so that he needs help. And just reconsider, coming into my, sphere of ridiculousness. This guy wasn't having it. The other guy, completely different.
I had not asked.
Response.
When he left your property, did you see which direction he headed?
He was going northwest.
Okay. Thank you, sir. I don't have any other questions.
All right, sir.
Here we go.
Mr. Brooks, do you have any questions for this
Now-
witness?
Yeah, I do. It's my understanding that the defense questions are shorter because you don't want to highlight whatever proof the prosecution has brought. And if you don't think that they've brought anything worthwhile or of any substance, you just don't ask anything. Go, well, why even respond to it? Because you can. But Darrell, this whole concept is lost on Darrell. Okay, I've picked up on it after many, many days and countless numbers of hours, frying my IQ points, trying to understand how this goes. But a real attorney would take what was questioned and maybe point out things that could have, was it light enough for you to really see him? Or, you were just trying to chase him away. Was there enough time? Or, point out anything. How do you know what direction he went in? Did you see him go further? Could he have turned around? That would have been speculative, but you know what I mean. Just kind of shedding out any kind of like darkness over his light. But not Darrell.
Yes, I do, and I object to being called that name for the record.
Attention to me.
Do you recall giving a statement to Officer Probst?
I don't know his name, but
Gross.
I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who's you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
I think he was trying to get. I don't like his face there. I don't like his response too. He's trying to make a direct comment saying this person was darker complected or brown complected or whatever, without making a judgment of what the lineage could be, because how could you know? It could be a multiple ways that a person gets that sort of complexion. Darrell, it doesn't make him wrong. It makes it descriptive. I'm not even sure it makes it racist. I'm not even sure.
Who's you?
You. I'm looking at you.
he gets so stuck in on who is you as a legal argument.
And how did you come to that conclusion, the you conclusion?
You conclusion. I'm
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description
Now he's going to argue with him for the rest of the time.
on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you?
I love it. He is not going to let Darrell off the hook on this. He has got Darrell. He's got you, Darrell. It's you. I'm looking at you. You.
Did you come to that conclusion?
Oh my God.
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting.
That's testimony.
Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
But Darrell is just a little tiny squirt of a man.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
Okay, well,
You have your
first
shoes
of all,
on or off right now?
Darrell, you were a little plumper before you were in jail for a full year. Let's be honest. Because we all know he gains back all this weight after he's out of the spotlight. But Darrell is not a tall man, so he's below the average, I think, in height. And
Would
this
it
guy
be fair
you
to
said
say
was
that I'm
out
not
of
5'9"
average height.
160 pounds?
If
That's
you
average
take
height
shoes
for-
off and step out of them,
Oh my gosh.
they could have a better.
Well, I'm not going to have
better
them do that,
See, now we're
but
having
if you're
an
able to
argument.
answer the question,
Awesome.
do you agree?
I'd
or
have to be
disagree?
standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objections.
Grounds.
Irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the sustain.
Thank you.
Next question, please.
You also said that, well, the narrative in the report.
Had he, I'm sorry, I know I'm talking too much today, but had he approached that questioning of his appearance and the description more professionally, there was a small chance he may have cast a little shade on that. Now, do I think that that's going to win the case for him, even if he was able to do that in this particular case? No. There's pictures of him committing this crime and then running piece by... Okay. There was a police officer who was ambushed and shot very close to me. In fact, it was an officer that I had just a few days earlier been on a call with. And so this hit me very, very hard. She was a fantastic officer. She did her job. She was simply working an overtime shift right around the Christmas time. I'm not going to go into that too much further. But the actual event, of course, is on her dash cam. And then there are subsequent camera shots through CCTV and on those little police cameras that are in the not so great parts of town. all the way from the area in which it happened to the area of their subsequent crime, of their next crime. So they actually followed these people all the way to the next crime, which, by the way, was another pew-pew in which somebody else lost their life. So they were busy that night. But it is just goes to show you that a lot of what we do these days, like over 80 to 90%, is on camera somewhere. We are on camera. If you are picking your nose, somebody can see that and document it in 5 years. That you were picking your nose on the corner of Main and Central, whatever time. It happens. So even if he could cast even a slight shade of doubt over this, because his appearance is different, because his weight is different, because his hair is different, whatever it is, because of the way the guy described him on the non-emergent line when he called it out, whatever it was, there are so many other pieces of identifying information. Darrell has this is not the hill he needs to die on. And he not only died on it, he shot himself in the foot and then in the face, because he just looked stupid going after this guy. That was way too long.
Said that the individual was later identified. Would that be fair to say?
Fair to say?
Yeah, that'd be fair to say.
God, we would be dead if we.
And so would it also be fair to say that
Fair to say.
because the individual was identified later, that's how you came to the conclusion of who it may have been in your yard?
Objection, I think that's
Grounds?
a statement, Your Honor. He's, again, reading a police report,
That's a question.
not authored by this witness. It's beyond the scope of the witness's knowledge.
It's actually the report that he
Mr.
gave.
Brooks, I've heard enough. If the objection is sustained, you may rephrase your question.
He may have a question in there, actually. I can't figure it out. That's what lawyers for. One of you said that he reads and you're waiting for it to go click. If I was any good at editing these things, I would totally put that sound in and click, click, whatever it is that typewriters do. I would put that in for you. There's another one that said every time he mispronounces a word, we needed to document it. I said I need to make a proper list. I do. I need to go back through this and make a proper list of everything he mispronounces. Tacket and fur to say.
Did you follow the investigation after you had given the report on the non-emergency line?
It's kind of hard not to see it on TV. Can I clarify something? Or?
No.
There's not a question just
Oh,
yet,
okay.
so
All right.
the state will have an opportunity to redirect if they deem it appropriate.
Okay.
Thank you.
So you made reference to it was kind of hard not to see it on the news. Would that be fair to say?
Yeah.
He was all over the news.
And would it be fair to say that from those news reports you gained additional information that you didn't have that night?
Actually, what I did is went into work the next morning and pulled up the police report on the internet, and there you were in a mugshot. And I'm like, that's the guy.
So you got a further description from a mugshot?
No, I didn't get a further description. At the time, I didn't care who you were
Recognized your
when you were in
mugshot.
my yard. I didn't know who you were, what you had done, where you had
Recognition is not gaining further information.
been, any of that
So-
stuff.
so-
All
Let him finish.
I'm saying is you were trespassing in my yard at that time. And that's all I can say. Other than that, that's all I can confirm. I don't know what you did. I don't know where you were. I don't know any of the other stuff. All I know is you were the guy in my yard.
The guy that you said was 5'9", 160 pounds.
Yeah.
Objection, argumentative,
Grounds.
asked and answered.
Thank you.
Grounds.
Sustained.
Thank you.
Next question, you don't have to answer that.
And what prompted you to read or pull up the police report?
Objection, irrelevant.
Grounds. He said it. He brought it out there.
Overruled, he may answer.
I was curious of actually who you were. And
what,
if you were the person that actually had done the atrocities that were on television.
and what prompted the curiosity?
A stranger was in my yard, unannounced, trespassing, asked me to leave, and they ended up catching somebody for doing something very bad, and I was wondering if that was the individual that had cut through my yard.
Let's unpack that for a second. When you come as a normal, everyday, average person, so close to that level of evil, it actually impacts you negatively. Now, this guy seems to be a strong-willed, very, like, he has cut boundaries in his life, doesn't want you in his yard, doesn't want you around his what he's worked for, what he deems he wants to keep safe. Like I said, the illusion of some control over that environment. And he deserves to have that. He's worked for it. Good for him. But when you come so close to that level of evil, he felt it, maybe? I don't know. But when he confirmed it, a little click goes in your brain, I think. So that's significant to a person. I'm not sure he wants to highlight this for the jury. Don't worry, dude.
So it'd be fair to say at the time you wasn't privy to that knowledge yet.
Vague.
Grounds.
He is not twisting your
Sustained
words.
to the
Don't
form
worry.
of the question.
At the time you pulled up the police report, as you say, you had no knowledge of the identity of the individual.
I didn't know that you were going to be the person that had done that.
You keep referring to the you.
You. I'm looking into your eyes right now. You're the guy I'm talking about when I refer to you.
And the record should reflect that the witness used his right hand and index finger to point directly at the defendant. Next question, please.
You, Darrell. See? I think this guy is genuinely worried that Darrell is twisting his words. And if you were to watch this, if he were to watch this back, he could see that Darrell's just making it. Look at it. He's panicking. Darrell's in a straight panic. Writing with the little inside of his pen. Because they won't give him a whole pen in case I don't know.
So you just made reference to looking the you in the eyes, but you would need.
What would you prefer I call you?
You would need.
Because you're not going by Darrell Brooks.
You would need me to step out of my shoes to tell my height and weight, right?
I'd have to also stand 2 feet from you.
That's argumentative.
Mr. Brooks, you're directed under 90611 to ask a question and not argue with the witness.
All right, so the state didn't even get an opportunity to object to that. And I really think this guy thinks his words are being twisted. So he is getting a little defensive. He needs to take a breath and let them protect his testimony. He's fine. There's nothing wrong with anything you've said so far.
Thank
What's
you.
the question?
It was argumentative. Please rephrase your question.
I mean,
The
wish they could have
witness
a
is
witness
instructed to wait until a question is asked, and if there's any objection, then I rule on it first. Go ahead, next question.
It sounds like he the one arguing.
Because we're all rooting for the guy who calls Darrell
Last
you.
comment, Mr. Brooks, you're not testifying right now.
Thank
You'll have
you.
an opportunity if you choose to do that later. Please ask a question.
Yeah, I'm gonna get to it.
Get to it. Now I'm going to be intimidating to you and get to it. Get. G-I-T. Get. Going down in our notebook. Get to it. Typewriter. Tick, 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 ding. Tick, 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 ding. Tick, 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 tick.
Any reason why you didn't give a written statement to law enforcement?
Objection, argumentative,
Grounds.
irrelevant.
How's it argumentative?
Sustained. As to the form of the question. Next question, please.
Did you at any time give a written statement to law enforcement?
I don't believe so.
Any reason why not?
Objection,
They didn't ask
Grounds.
for it.
argumentative.
Normal people do not know the process. Sometimes they want a written statement. Sometimes they'll just take your verbal statement and they do their thing with it. I don't know what they're talking about or what they're doing. And I worked closely with them as a paramedic. I have no idea what they require. They tell you and you do it. There's,
Irrelevant.
do
Sustained.
extra work, stupid.
Grounds for the sustain?
Mr. Brooks, please ask your next question.
Grounds for the sustain?
Grounds for the Can you point out how stupid I am to the jury? Sorry, everybody. I can't keep my mouth closed today. Been too many days since I've done this.
You said you pulled up the police report at work the next day,
We
right?
didn't.
No, I pulled up your mugshot.
Well, you did say police report. Would that be fair to say?
You can answer that.
I just pulled up a mugshot.
You don't recall saying that you pulled up the police report specifically?
I specifically wanted to pull up the picture of the person that had committed those atrocities to see if that was the person that had cut through my yard, which confirmed it was.
And did you pull up the complaint?
No.
Have you ever seen the complaint?
I don't believe I have.
Have you yourself filed a complaint?
Nope.
Any reason why not?
Objection,
Grounds.
relevant,
Sustained.
argumentative.
As to the form of the question and on relevance. Next question.
Do you recall who subpoenaed you to testify here today?
It's on the subpoena.
Don't know, don't care.
You don't recall?
I'd have to have the subpoena with me to read the name.
Do you recall if it was the district attorney's office?
It
You
was.
just said no. Semantics.
Do you recall about how long ago you received the subpoena?
You can answer that.
A month or two ago, a couple months ago. I didn't.
Write it down in my date book.
I got a subpoena, so that's all I know, and I had to show up at a certain time.
Surprised.
So you knew it was a possibility that you would be called to testify.
I had no expectation of the subpoena until I went to the DA's office.
He had an inkling that he was involved in this more than he wanted to be when he brought up the mugshot and found out that the person that that was in his presence the night before was a monster who had done all these things. Probably hopeful that he wasn't in it enough. Then he gets the subpoena. Okay, I have a subpoena. He checks with the district attorney's office and they question and get an idea of what he has to offer and say, you know what, you're probably going to be. And then he knows. That's when he knows.
So you went to the DA's office?
They want to know. They ask.
He doesn't want to be twisted.
They want to see if you're worth having as a witness, or if you actually had any information that was pertinent to the case.
Yes.
And so would it be fair to say that you felt that you did?
I didn't know.
Grounds.
I didn't know.
I'll sustain as to the form of the question that strike the last response. Please rephrase.
Did you feel that you had information that would be relevant to the matter?
That's an irrelevant question,
Grounds.
Your Honor.
Sustained. Next question, please.
Grounds for the sustain, Your Honor.
Next question, please.
How would he
Grounds for
know?
the sustain, Your Honor.
It's beyond what
question,
this guy
please.
would know.
Is that a judicial determination, Your Honor?
Ask your next question, please.
When you went to the district attorney's office, do you recall whom you spoke with?
There was 3 or 4 people there. I don't recall their names. I recall their faces.
You said you do recall the names, not the faces?
No, I recall their faces, not their names.
Oh. Do you see any of those district attorneys in court here today?
I see one district attorney and one officer was in the room.
And for the record and for the jury, can you identify whom you're referring to?
I'd have to point.
I'll
Her,
stipulate,
yep.
Your Honor, I met with
And
Mr. Backler.
this officer here, sitting behind them.
All right, so the
Yes,
witness has
Detective.
pointed to
I think that helps him
District
out.
Attorney Sue
That
Opper
he's not
and Detective Casey.
This poor witness has one fear. He's afraid of one thing. He's afraid of weakening the case against Darrell Brooks. He knows he was in the presence of a monster. He knows he came this close to being involved, and certainly was to a certain extent. And his only fear right now is that he's in any way, shape, or form weakening this case. That's all he's afraid of. But in this moment, he doesn't know. All he feels is Darrell's attack. That's all he feels. And Darrell doesn't know how to do anything but attack. So hopefully the fact, they have to stay stoic. I get that. But hopefully the fact that she spoke him to say, I stipulate that he spoke to me, gets him to say, okay, that I did what I did. That's what happened. He's right. Okay. Go on. You're doing great.
And that was around the time you first received the subpoena?
It was the time that the subpoena told me to show up.
Do you recall ever being told about the plaintiff in this matter?
Objection
Grounds.
vague.
Sustained as to the form of the question.
Do you know who the plaintiff is in this matter?
Objection
Grounds.
vague, beyond the
Grounds.
scope of the witness's knowledge, legally inaccurate.
Sustained as to the form of the question.
Did Attorney Opper ever tell you who the plaintiff was in this matter?
The subpoena told me who the plaintiff was.
And do you recall who the plaintiff is?
Darrell Brooks.
That's the plaintiff?
Or not the plaintiff, the plaintiff is, I think, city of Waukesha or state of Wisconsin, I'm not sure.
And it'd be fair to say that that's not a living, breathing human being.
Objection,
Grounds.
relevance.
Sustained, not relevant. Next question.
Are you aware that only a living, breathing human being can make a claim?
Objection,
Grounds.
irrelevant, argumentative.
Grounds?
Sustained for those reasons, and it's also not an accurate statement of the law.
Definitely not argumentative.
Mr. Brooks, under 90611, I need you to move on from this topic and ask a different line of questions, please.
Move on from what topic, Your Honor?
Next question, sir.
Can I know what topic you're referring to, Your Honor?
Next question, please.
If I don't know the topic, how would I know to go in a different direction?
Mr. Brooks, under 90611, I need you to ask a question.
Do you know if there's even a plaintiff in this matter?
Objection, irrelevant.
Grounds.
Sustained. Under 90611, sir, please move on from this topic or I will declare your cross-examination closed.
Under what law and fact, Your Honor?
Under 90611, please ask a question.
And where can I find 90611?
This is your last opportunity.
In this book right here, in this book right here, that you with these laminated things in color that with the rules and stuff that she's given you all along.
Opportunity to ask a question, sir.
Your Honor, the jury deserves to know this information.
All right, then the state, any redirect?
No redirect. Thank you, Judge.
All right, thank you, sir. You may step down.
In other words, he didn't dismantle.
State may call its
anything you
next
said,
witness.
sir.
Thank you, Sean. Have a good day.
I may have to pause. I feel like I've done these guys before.
You may
Have
call.
we already done these?
The state calls now.
All right, I'm gonna take a break because I hear Harley smashing through the door because she hears her friends across the street. So thank you. I think I've already done these, but you know what? Maybe it's in my dreams or my nightmares. I know, Harley. I know. Okay, so let me go take her across the street and I will see you later. Bye-bye.